Be ready. Start. The counsel for the plaintiff has argued that the plaintiff has already pleaded that it was defendant number 3 who was dealing with the plaintiff and has invited attention to paragraph 5 of the plaint that the plaintiff inquired from both of them regarding any pending litigation stroke dispute with regard to the said property, to which the director of defendant number 2 replied that due to the active role and intervention of defendant number 1, all the pending disputes stroke litigation relating to the said property have been sorted, and that the said property was free from all encumbrances, and that defendant number 1 and 2 jointly owned the suit property, and the same nowhere contains any plea of any such representation. There is a difference between pleading Mr. Raghav to be the director and pleading him to have represented defendant number 2 to be the owner of the property. The counsel for the plaintiff forgets that it is not the plea of the plaintiff that the said Mr. Raghav falsely represented that defendant number 2 was the owner, and on account of such false misrepresentation is liable in his personal capacity to convey the property. There is similarly no plea with respect to defendant number 4. The counsel for the plaintiff states that he will amend the written statement. After hearing the question of permitting amendment does not arise. The counsel for the defendants number 3 and 4 also points out that the plaintiff applied for impleadment as far back as in 2017, and notwithstanding the same, when filing the suit in the year 2019, did not implead the defendants number 3 and 4. It thus indeed appears that the relief of specific performance does not require any issues to be framed and is liable to be dismissed forthwith. On inquiry, it is stated that the defendant number 1 in the written statement has admitted receipt of rupees 1.60 crores. It thus appears that the plaintiff is only entitled to a decree for rupees 1.60 crores, which can be passed forthwith. I, however, refrain from passing a decree for a recovery of rupees 1.60 crores with interest against defendant number 1, who is unrepresented today. The counsel for the plaintiff states that the plaintiff is seeking specific performance against all the defendants. On inquiry, that without pleading the existence of agreement with defendants number 3 and 4, how can the plaintiff be entitled to specific performance against the defendants number 3 and 4? The counsel reiterates that though defendants number 3 and 4 were not a party in the suit as originally instituted, but since the word defendants was used, they on impleadment would be covered thereby. I am unable to agree. The counsel for the plaintiff has, during the hearing, also stated that the defendant number 1 is still the owner, but on it being pointed out that if specific performance is sought only against defendant number 1, it has to be a case under section 12 of the Specific Relief Act 1963, which has not been made out. The counsel for the plaintiff states that he does not want this part to be recorded. The plaintiff, paragraphs 6 and 7 of the plaint pertaining to negotiations regarding sale price and modality of payment thereof, has repeatedly pleaded the part of the sale consideration payable to defendant number 1 and part payable to defendant number 2 and the mode of payment to defendant number 1 and defendant number 2, and the only inference wherefrom can be that when the plaintiff in the plaint refers to defendants, the reference is to defendants number 1 and 2 only. There is no plea of payment of any portion of sale consideration to defendants number 3 and 4. Further, the plaintiff in paragraph 11 of the plaint has pleaded having applied for impleadment and having had negotiations at that stage with all the parties, disclosing that at that stage the negotiations claimed are not only with defendants number 1 and 2 but also with defendants number 3 and 4. Still, while instituting the suit, the defendants number 3 and 4 were not impleaded. The plaintiffs therein had instituted the suit for declaration of their title and for recovery of possession of immovable property, claiming that the defendant was put in possession of the property under an agreement of sale of the property to the defendant by the predecessor of the plaintiffs, and the time for performance of the agreement of sale expired long back without the defendant enforcing the same, but the defendant had remained in possession of the property. The defendant was found to have filed a suit for specific performance which had been dismissed. However, in the interest of justice, considered it necessary to deal with the question with a view to give quietus to the litigation which was pending for 3 decades, and directed delivery of possession by the defendant subject to the plaintiff refunding the earnest money of rupees 1 lakhs received from the defendant to the defendant. Thank you.